Okay, we look at the process that the Supreme Court follows as they render their 70 some odd decisions every year, and by issuing these 70 rulings, manage to filter down procedures that all courts will follow, at least those willing to cooperate with the Supreme Court. This first slide deals with some of the terminology involved in whether or not the case can even be considered by the court. Now, that being said, since I think around the 1920s, based on a law passed by Congress, the court has essentially ultimate jurisdiction on, or ultimate authority on, what cases it accepts. So there could be, if you look on this list, there's something called justiciability. Can there be a judicial solution? 99 out of 100 people could look at a particular case and conclude, there's really not a judicial solution. But if 4 justices decide we want to take the case anyway, they can take the case. But we'll tick down this list just to go over it. We've already talked about the first one. In order to move your case out of the state court, and remember, a massive percentage of cases are state-based cases, you have to prove that the point of controversy in the case that you want looked at involves a federal question, something to do with federal law, something to do with the text of the Constitution, or the mother lode, something to do with one of the amendments. If you can't make that case to the acceptability of 4 justices, that's it, you're done. Whatever the final decision of your particular state is the final decision. And as I mentioned previously, if it was a criminal matter, you would then have the opportunity to perhaps appeal to that state's governor for some sort of clemency. The second is something called standing. The parties involved, or the aggrieved party, has to demonstrate harm, for lack of a better word. They have something of monetary value. So somehow they have to justify that this is something that has hurt them. Now, that's generally pretty easy in a criminal matter. You're being fined, you're going to jail, you're going to be put to death. It can be when you're dealing with civil matters, with questioning actions of the federal bureaucracy, they choose to do A rather than B. Sometimes it can be a little more tricky. The whole point of this is to avoid make-believe cases that are just created to get the court to answer a question that you want answered. So you create a fake case. To some degree, the famous case involving the bus boycott in Rosa Parks, name escaped me for a minute. Largely it was sort of a setup case, in that the circumstances were all somewhat prearranged, but the fact of the matter is she was told, based upon her color, to sit in a certain part of the bus, so there was still demonstrable harm. The one I mentioned previously is there, if the judges issue a ruling, is it going to have an impact? Is there any ability for the court to really affect the outcome of the circumstances? Political questions. The court, and I may have mentioned this to you at the very beginning, the court tries to stay out of political mud fights between the 2 branches. It has become increasingly difficult in the 21st century, and the court is getting cases from the Trump administration one after another, particularly after the Democrats took control of the House of Representatives. They would like to wiggle their way out of it. You could even argue to some degree their foot dragging is maybe a conscious or subconscious desire to perhaps have the case not matter because he doesn't get reelected, and a Democratic president changes policies completely, in which case the people who are appealing his ruling, immigrants or whatever, they won't be harmed anymore, because assuming the Democratic president would take alternative positions. At that point, you have another factor that impacts whether cases are heard, and that's called whether the question is moot, M-O-O-T, in that it doesn't matter anymore. So if you are an undocumented alien who has been harmed by an executive order by the president, and you're making the case that it's violating your 14th Amendment rights, or violating 14th Amendment rights, or somehow the president overstepped his authority, we have a text of the Constitution matter, then, as I said, Trump loses, assuming President Biden comes in and undoes those decisions, you're no longer harmed. So your case would then become moot. And the other one is it's very difficult to pursue civil cases against government officials. That's called sovereign immunity. That applies to state government officials, local government officials, if they're just doing their job. And in the course of doing their job, the consequences of it harms you. That doesn't mean you, in fact, what it does mean is you can't sue them for that if they're just doing their job. Now, if you can prove malice, if you've been wrongly convicted and you can prove that they had information to show that you perhaps weren't guilty or there were other, and they chose to ignore it, then you might have a case. But if they just made a mistake, if using the evidence at the time they thought you were the one who did it, they put you on trial and a jury convicted you, you're out of luck when it comes to a civil suit. You're then at the mercy of whoever put you in jail, the state, the federal government, to compensate you for that. Speaking of compensation, how do you pay for all of this? One of the, and if you saw my email earlier, I mentioned Gideon's trumpet. You will see as part of that that he, as a poor person, he got his case accepted through his own personal determination. But to be represented, he had to get a law firm to represent him for free. That is what's called informa pauperis, in the form of a pauper. Many prestigious legal groups, law firms, like to do a certain percentage, particularly, and in the case, this is true in this case with Abe Fortas, when you're appearing before the Supreme Court, because nothing allows you to pump up the rates you charge for your regular customers if you can demonstrate a track record of having appeared before the Supreme Court and having done so successfully. It's getting to be quite a while ago now. Several summers ago, I got to participate in a Supreme Court Institute, and it's an organization called Street Law, but they're largely supported by a law firm. I think it's called the Day Law Firm. I forget the full title, whose offices are right by Capitol Hill. They are one of the top groups. And we met one of the lawyers he had two cases before the Supreme Court that very year, and one of them was one that his law firm was taking on behalf of an immigrant, had to do with being expelled from the United States for something that had happened in Yugoslavia. So you get to the Supreme Court and you are a pauper. First of all, congratulations for that. Second of all, you're probably going to get a pretty good legal firm. In this case, Gideon gets Abe Fortas, the top constitutional lawyer in the country at the time, to represent him. Fee shifting applies to civil cases where, and you see this on advertisements on TV all the time, that if lawyers take a piece of whatever you get in a settlement. Class action suits is if the thing you are suing about harms a lot of people, you can get them all together, and you don't even have to have them named. You can just say anybody harmed by the action of this company, and you spread the burden of the cost, but of course you also spread the benefits of winning your case. And then, of course, I mentioned Rosa Parks earlier. If you have organizations that support you, the NAACP and Rosa Parks, the ACLU, we'll talk about it later in this video, representing captured Al-Qaeda people in Guantanamo Bay. And there was a conservative group that represented a lot of people who claimed to have been harmed by Obamacare. Common everyday people who they would pay the freight for or literally provide the representation, the lawyers for their group. So all of these come into play in kind of pre-decision, whether your case is even one of the great 70 that get admitted. We'll talk about how you get to be one of those 70 in a moment. Okay, getting to be one of the 70 that appear before the Supreme Court. There are a handful of cases that the court has to review. These are usually big cases involving state versus state controversies, occasionally involving international lawsuits between citizens of the United States and a foreign government. There was a famous one, actually, I think it's been percolating through the court for a long, long time, involving the hostage crisis in Iran. What happens is you've lost your case at the lower court. You've lost it as high as you can go in the state system, or if you've lost at the Court of Appeals level in the federal system, and you want the Supreme Court to review it, you submit what's referred to as a petition. You're requesting, with justification and what things you want looked at, the Supreme Court to invite you to present your case before them. That invitation is referred to as a writ of certiorari, nicknamed cert. You want cert granted. What that is the Supreme Court ordering whatever court this is coming from to send them all information about your case. So it's a symbolic invitation to appear before the Supreme Court. They get, I mentioned, roughly 7,000 petitions for cert. They sort through them. We'll talk about the role of their law clerks. It's something I want you to watch for in the movie too. And they grant cert to the 30, the 40, the 50, the 60, whatever it is that makes up the high percentage of the cases that they hear. Now, it only takes 4. That's why it's called the rule of 4. It's not very often known who the 4 were, and you certainly don't know why. You may be all excited, oh my God, I got a writ of certiorari, 4 justices were interested in my case. Well, 3 of them may be because they want to rule for the other side. I mean, you just don't know for whatever reason. Well, we'll talk about some reasons here momentarily. They have issued the writ, and wow, I mean, that's amazing. You are now one of the 70. Now, why? If you look on the previous slide, one is, as I kind of implied earlier, the 4 justices found something in your argument interesting enough and needy enough for the court to hear it and ultimately issue a ruling. The most common source of some of their bigger cases tend to be when the circuits, if you remember that map from the previous lesson, issue different rulings. And this happened, and this sort of forced the issue on the same-sex marriage. You had the Cincinnati Circuit ruling against requiring same-sex marriage license to be issued under the 14th Amendment, and then the Ninth Circuit, and I think one other circuit, saying, yes, you do. And the court accepts the fact that you cannot have the 14th Amendment meaning 2 different things in 2 different places in this country. So circuit disagreements, where they're having to come in and settle a dispute between different circuits looking at the same issue. Occasionally there is, the states, particularly, I was thinking about the death penalty, states interpreting the 8th Amendment differently and deciding when to execute, how to execute. Is something they stepped in the early 70s to say this has gotten out of control. You have some states executing people at the drop of the hat, some states not executing at all, some states executing for crimes that did not involve the taking of a life. So they stepped in, stopped all executions, created a common superstructure for the death penalty, and then states who chose to still have the death penalty then used that as a guide. Federal law vagueness. Now, this is assuming they're not willing to defer to the federal government. And it's not so much the bureaucracy that they're questioning, is they're questioning the degree of deference, the degree of independence they've given to the executive branch. The court does not like the executive branch acting like Congress. They want Congress to act like Congress. Now, if they determine that this was an appropriate gift of discretion to the executive branch because of the expertise needed, etc., and then the executive branch made their decisions, and assuming they follow proper procedures, then you're out of luck. That's something referred to as the Chevron deference that I mentioned earlier. And then the last thing I wanted to mention was each of the justices have 3 or 4, and I think the Chief Justice can have as many as 5 law clerks for a year, coming out of law school, generally speaking, and not your low-level law schools, the best law schools in the country. You have these clerks are the ones that open the petitions, and the justices are not necessarily going to see at first blush every one of the 7,000 petitions that come to them. The clerks will get a sense of what Justice Ginsburg is interested in, what Justice Gorsuch is interested in, and will flag those. And I want you to watch for that. in the Gideon movie. If you watch it, you'll see the first person who actually catches on to Gideon's petition is indeed a law clerk. The picture on that slide actually shows you Justice Kennedy with his law clerks one year in the 80s. Well, one of them is Brett Kavanaugh and the other is Neil Gorsuch, both now on the Supreme Court. So it is obviously a pretty prestigious thing to obtain. So we'll come back to the process that it goes through once you're one of the 70 in a few moments. Okay, you should have looked over the slide called process sequence. It starts to the left side. The legal teams representing the two sides write up their legal arguments for why the court should rule in their favor. They're making just obviously general arguments. They are examining the particular facts involved. And most importantly, they are looking at previous court decisions to justify their point of view. We'll talk about that on the next slide when we come to the actual decision process. These are submitted weeks ahead of time. They also include something we've talked about previously in a different context when it comes to interest group. They can also include outside briefs, submissions by legal teams not part of the Smith versus Jones or U.S. versus Fletcher teams. These are called amicus curiae briefs, friends of the court briefs. I guess there's different scholarship on how important these are. Sometimes you get there are some cases where there are 50 or 60 briefs submitted by different groups, and the kind of the inside scuttlebutt of how the court works is a lot of these tend to be ignored. There may be certain justices who tend towards looking at certain groups who might read theirs. In all likelihood, it's going to be the clerks that might flag some argument that was brought up. In that, though, I want to pause to mention if the U.S. government is not part of the decision, and the U.S. government, or part of a case, the U.S. government is not part of, in some cases, many of the Supreme Court cases, then the office of the Solicitor General, who is the legal representative of the United States to the Supreme Court, they actually have an office in the Supreme Court building. You'd like to, if it's Jones versus New York or whatever, Smith versus Sanders, you'd love to have a brief submitted on your behalf by the Solicitor General to favor you. It does put a little more weight on your arguments if the official position of the United States government is defending your point of view. So that one really does matter of all the amicus briefs. So they are submitted weeks ahead of time. The justices and their law clerks have a chance to pore over them in great depth, preparing for what's called oral arguments. This is where the thing that actually takes place in the Supreme Court chamber. It can be pretty intimidating. It is the all-star game for lawyers. The 9 justices come in. Your case is scheduled. They usually hear cases in the morning, usually 2 a day, 2 or 3 times a week. The general timetable is each side gets 30 minutes to present their case. And this is high stakes. I mean, you may have, and you should have prepared a 30-minute presentation justifying your argument. You'll see brief snippets of these that they took right from the transcript in the Gideon film, and in fact, that's why it's worthwhile watching. And this set is pretty similar to the actual Supreme Court as well. So you want to be prepared for 30 minutes of justifying your point of view, but what often happens, and you'll see it played out in the video, is almost immediately you'll be interrupted by questions from the justices, and you'll have to be able to respond to those questions. And while doing so, also bring up the points you wanted to make in your original presentation. Because they may, depending on the case, depending on them, you might get 3 words out, and then all of a sudden you're peppered with one question after another, and that's part of your 30 minutes. And if they've just asked you one question after another and the 30 minutes are up, the 30 minutes are up. So you have to figure out a way to, in answering their questions, make your key points. Trying to keep your answers pretty succinct, too, is important. The conservative pair of Scalia and Thomas were sort of interesting. Scalia was a very aggressive questioner, whereas I don't think Clarence Thomas has asked more than 3 questions in the entire time he's been on the court since 1991. So very different ways to behave as a justice. Um, the other side gets their 30 minutes, and that's it. You're done. Very, very big cases like Bush versus Gore, I think even the Obamacare case, maybe even the same-sex marriage case, the court agreed to a longer period of time. Sometimes third or fourth parties will be allowed periods of time to also engage in oral arguments. Those are pretty rare. It's primarily the legal teams representing the two parties in the case. So that's oral arguments. If we had class and we had the time, we might have a lengthy discussion on the matter of, and you see there's a drawing there, the matter of whether they should be televised. No federal court is televised, and all Chief Justices right up to the current one are digging their feet in as to, no, we don't want this to become a media circus. Plus, we'll put these nice people who do the drawings out of work. That was a joke. All right, so they've processed the briefs, they've gotten the information from their clerks, they have engaged in oral arguments. What usually will happen at the first conference, this is in a conference room just off the Chief Justice's office, the first time after the oral arguments, the Chief Justice will bring up, hey, we just heard arguments in Smith versus Jones. What are your reactions? And it's just sort of an initial, to borrow a term from another chapter, straw poll. Because if it's and many of the cases are not dramatic, Brown versus the Board of Education, and he does an initial sort of at first blush, what do you think about this case? And it's 9-0 for Jones. Ooh, they're done. I mean, because he's in the majority, will get to decide who writes the decision, and he can say, all right, let's do a vote right now, and let's start the process of writing out the decision. Because that will take time. The justice who is assigned to writing out the decision will need some time to do that. If it's, 3 for Jones, 3 for Smith, and 3 I don't know, then they're going to have to keep bringing it back up. And what will happen over the course of the ensuing weeks is they will be discussing with each other. They will have gotten the original, the 3 for Jones will be, in the ear of the 3 who were sitting on the fence, and the same is true for the 3 for Smith. They might even be, as they discussed, why were you for Smith? The Jones people may realize that they're not really passionately for Smith. Maybe I can convince them to come to my side. And it's very important as we shift to that last image there, the decision. Chief Justices are sort of shepherding this. Now he is the Chief Justice, but he's not their boss. So he has to do so with a delicate hand, and he wants to try to, in as many cases as possible, make the majority as significant as possible. He knows, he read his Hamilton, he read his Federalist 78. He knows, and every Chief Justice knows, the judicial branch is by far the weakest branch. The more that they can speak with one voice, 9-0, the better. One of the things noted about the Marshall Court, John Marshall, in the early 19th century, was he did get one unanimous decision after another. And this was despite that he faced 3 decades of Jeffersonian appointments to the court. It just shows the level of skill he had. There's the old story about Warren going after the 9th vote in Brown, that he knew this was going to be an incredibly controversial decision. There was a justice, and I apologize for forgetting his name, from Kentucky, who was, I don't know if personally he was racist, but he was raised in a segregationist society, and he was really reluctant to rule for Brown. And Warren wanted it so much that he held the case over to the following year so he could keep on working on this guy, keep on hammering this guy. Finally, the guy just basically surrendered and said, fine, I will vote for Brown. So Brown versus the Board of Education ends up being a 9-0 vote. Its impact took a decade to influence the United States, even with the 9-0 vote. If that decision had been 5-4, I think the opposition to desegregating would have potentially dragged on even longer and might even have been potentially successful. I'll pause here. There's another repeat of this slide just talking about when they made their decisions, how does this appear in written form? All right, so at some point, the Chief Justice decides I've made my best effort to get a 9-0 vote. Um, we're done. It's 6-3, it's 5-4, whatever it is. We've made our days, weeks, months of trying to pump up the vote one way or another, but it's up. And I don't know how this year will play out because of the coronavirus, but normally they would finish third or fourth week in June. So they also have issues of their term coming to an end. There are rare circumstances. In the case of the Nixon tapes, they handled that one over the course of the summer. So it's done, and it's now time to communicate with the world what the decision is. If you were listening carefully, I mentioned earlier, if the Chief Justice is in the majority, whether it's 5 or 9, he gets to decide who writes the official opinion of the court. And that includes he can choose to pick himself. If he is not, if he is in the minority, and that has not happened a great deal recently with the Roberts Court, but if he is, whoever has the most experience on the Supreme Court in the majority, they control who writes the opinion of the court. And it is the opinion of the opinion of the court is the one that matters. It leads off. It is the Supreme Court is doing this. This is our decision, and this is the official rationale that we can get 5 justices to agree to. Or, well, maybe not even that. That's probably going too far. The outcome of the case in favor of Brown or in favor of the Topeka Board of Education is in that. The rationale could be different, which leads us to something called concurring opinions. You might have a justice who thinks Brown should win, fine, but is leery of the rationale that justices are making for that, and they want to lay out their own reason for why Brown should win, and probably it's to limit, well, at least offer a more limited justification for that ruling. Now, of course, you're also going to have justices who are voting on the other side if it's not 9-0, and they are free to express their opinion in what is referred to as a dissenting opinion. Um, these oftentimes are just venting as to, I can't believe the court ruled this way. Scalia was classic for those kind of dissenting opinions. Sometimes they matter. I mean, they become part of the record, and I am certain that the legal team for Brown, Thurgood Marshall was on it, dusted off John Marshall Harlan's dissent in Plessy versus Ferguson and just these ideas about the Constitution being colorblind, etc. Let's incorporate those in our arguments. So dissents historically can have a role in the long history of the court. In the short term, they tend to be just venting satisfaction for that particular justice or fuel to the political fires of those who support their particular argument. So those are the written communicated opinions. Okay, the next several slides are factors that limit the court being aggressive in the impact of their decisions on policy. What limits the court from being sort of a full and equal player with the legislature and the executive in terms of what the policy of the federal government of the United States should be? This first slide refers to stare decisis, let the decision stand. What had we decided before? There is intense pressure on the court to stay the course in a certain decision, to not leap from one extreme to the other or even minor variations, to show deference to previous decisions, to show consistency. Now, this slide mentions 2 particular instances, the most famous of which is Roe. The court, whether you agree, and Roe was a very complicated decision, but in the end, 5 justices agreed that the right to access an abortion was an individual right possessed by a woman. Now, like all rights, governments can restrict them in certain circumstances. So the game since 1974 is to keep poking and prodding at that flexibility. In some states, some conservative states, issuing more restrictive rulings, and over time, and we'll talk about this in the civil liberties and particularly the civil rights unit after spring break. Is trying to set a standard as to what is acceptable, what is not, and that's been the game that has been played since 1974. States do these restrictions, it percolates to the Supreme Court, and the Supreme Court has to decide how far it's gone. And I believe, I don't have those notes in front of me right now, but I believe sort of the standard that got created in the early 90s, courtesy of Sandra Day O'Connor, was something called the undue burden, sort of a standard applied to the states propose this regulation. Does that regulation present an undue burden to a woman in a particular state being able to access an abortion? Now, like all terminology, there's the whole beauty factor. It's in the eye of the beholder. What one person might be considering an undue burden, the next person over might not be. The court, on sort of the wish list of conservative groups, of evangelical Christian groups, etc., is that the presence of Gorsuch and Kavanaugh in combination with Thomas, Roberts, and Alito could potentially give you 5 justices who could go all the way back to 1974 and say, no, this is not a 14th Amendment protected national right. This is a police power decision, rules and regulations for the health, safety, and welfare of the community at the state level, thus overturning Roe and allowing the liberal states of New York and California to continue with very flexible abortion rules, and conservative states like Missouri and Alabama to ban them entirely, and every variation in between. Now, that would entail overturning precedent. That would entail overturning precedent with a 5-4 vote. We talked about how reluctant Warren was to overturn Plessy on a 5-4 vote. He wanted it 9-0. But it's still hanging out there, and there are cases coming up to the court that have come up to the court, will come up to the court into the next term, where there is an opportunity for that. The principle of stare decisis would suggest that they're probably not going to undo Roe, but it's been closing in on, what are we talking about now, 50 years? Roughly, not too far from the time between Plessy and Brown. So it's something we'll have to watch for. The other thing to mention is something called the Miranda rights. When who becomes Chief Justice, Rehnquist was he might even have been in law school. He thought it was the worst decision ever made by the Supreme Court. He railed against it when he was a young lawyer, when he was a young advocate, when he was first on the Supreme Court as just a justice. Thought it was terrible. I think it was the year 2000, a court case comes out of somewhere in the Midwest. And it really presents an opportunity. It was one of these borderline, should they have gotten a search warrant or not, or questioning of a suspect. And everybody thought, this is the Justice Rehnquist is going to use his position. He's going to fulfill his desire to finally overturn the requirement for Miranda that you absolutely have to read them in their rights before anything they can say can be used against him. And he didn't. And in his concurring opinion, he basically said it's become a way of life, and maybe it's not that much of a big deal anymore. So if the principle of stare decisis can wear down Rehnquist when it came to Miranda, you see just how powerful it potentially can be. Now, second limitation on the aggressiveness of the court is the court will tend to try to stay out of political questions. They would much rather prefer the political branches, the executive and the legislature at the federal level, or the political process in the states to settle the matter themselves. And in a future slide, I'll talk about why the court feels that it can't necessarily be a full political participant in the process. I think what examples did I use? Yes. After 9/11, President Bush, by executive order, created a process for holding enemy combatants in Guantanamo Bay. and not subjecting them to any sort of standard legal process. He did that by executive order. The ACLU represented one of those prisoners. It went to the Supreme Court, and the Supreme Court, I mean, they were almost to a justice really uncomfortable with the president exercising this. Now, could they have then taken that ruling and said, open the gates, let him out, or bring him to Washington, read him the Miranda rights, and put him on trial here? They could have, but they didn't. They sort of kicked the can down the road and said, we won't rule on whether or not the United States can hold enemy combatants in Guantanamo Bay. What we do rule on is it can't be done by executive order. It has to be done by legislation. It has to be a law passed by Congress that the president is then using. And in the meantime, enemy combatants in Guantanamo Bay are not going anywhere. So in very short order, the Congress engaged in writing the law to establish this process. It incorporated some legal procedures through the military system. They passed the law, the president initiated it. Immediately, the case was challenged to the Supreme Court, and about a year and a half later, the Supreme Court said, yep, it's good. You followed our instructions, and it is if the American people believe in the political process that these enemy combatants should be treated differently, then they elect different political leaders. We've made our call. You followed the proper process. Whether America accepts that process or not is a political question. And the other one was the Obamacare. It was and it doesn't exist anymore because of the Republican Congress and Trump. But one of the provisions was if you were a healthy individual who had the opportunity to get health insurance, either you could afford it on your own or it was offered to you as your part of employment, but you decided to take the money instead. You're young, you're healthy. Fine. We're not going to require you to get health insurance, but we are going to fine you for not participating in the system. And it was a graduate, I think the first year it was like a $90 fine, but it went up over to not an unconsequential amount of money. Well, that was one of the main proponents of Obamacare, and it was one of the main arguments against its constitutionality. There were 4 conservative judges who did not like many aspects of Obamacare, this one in particular, 4 who were all for it, maybe even in their hearts wanting it to be even more expansive. Medicare for All was the phrase then. And then you had Chief Justice John Roberts, who was still fairly early in his term. He took over in 2006. And he's not comfortable with, judicially, philosophically, with the position, but if he rules, it'll be a 5-4 ruling within a year or so after this incredible political act was passed. Did he really want to put the Roberts Court in that position? So he decides, for the sake of the Supreme Court, I need to get out of this. I need to show that it's a political question. So I can't throw it out, but I'm not crazy about the fining, which suggests a police power on behalf of the federal government when it comes to healthcare. So in his decision, he decides to call it a tax. And he says, Article 1, Section 8 does empower the Congress to pass taxes to pay for things in government. So this is a tax. Nobody had even brought it up as an argument. He just created this in a, some would argue, a desperate attempt to avoid getting the court in the position of, on a 5-4 vote, throwing out this incredible landmark piece of legislation. And then, needless to say, it's been a target of Republican politics for a decade. And we'll see what happens after we survive this bizarre year of 2020. They are looking at various aspects of it again with now Gorsuch and Kavanaugh on the court. So we'll see. But in general, courts are reluctant to fully engage in the political process, and they will either not accept cases. That's probably more frequent than the Roberts-Obama case. But if they do have to take the case, and they kind of had to take the case, they will try to wiggle out of it to avoid getting in the political mud fight of the particular time. Now, a lot of the cases that they get arise out of challenging decisions the federal government has made, and almost in a lot of times that's the executive branch has made a decision. Many of those cases go through the circuit court that's located in the District of Columbia that handles those cases directly. You're challenging the decision of the Securities and Exchange Commission. Your trial will be in the district court in Washington, D.C. You appeal to the district court that just serves Washington, D.C. They are almost exclusively dealing with decisions made by the federal government, usually administrative decisions. As I mentioned to you a couple of times, there's this standard from the 80s called the Chevron deference. So if you want to, the SEC has ruled against you, and you want the Supreme Court to overturn that ruling, you've been denied something, you've been fined, whatever. Just complaining about the decision, oh, the decision was, oh, boy, it was a dumb decision, or it really hurt us, and we're really hurting. Please save us, Supreme Court. You're not going to win. I mean, in fact, you're probably not even going to get your case to the Supreme Court. You have to show generally one of two things: that in making the decision, the process was violated. They did something that they should not have been doing, or they did something biased against you. If it's just this is things they decide and you can't demonstrate that you're not going to win challenging their decision. We're going to defer. Your only other option is to prove to them that the Congress went too far, gave up too much of their legislative power to the executive branch. You could potentially win there. They didn't even have the right to make the decision they made, to make the rule they did. It should have been something Congress did. So if you can prove those things, you have a chance. But Congress has become very sophisticated in how they write the laws. The executive branch administering laws is what they do, so they're generally very careful about having do it, which means you're not going to have a pretty good batting average. You're probably in many cases not even going to get your case to the Supreme Court, let alone a decision. So that's going to the court's not, and the court, even a majority of justices on the court might feel, Jesus, it was really wrong of the SEC to rule this way against this corporation or that corporation or this group, and I really feel bad for them. But no, we're not going to start getting in there picking winners and losers in the political process. Now, instead of making this limitation fourth, I probably should have made it first. And that's the structural position that the judicial branch has in our system. It is the weakest branch, as Alexander Hamilton pointed out in Federalist 78. They have the ability to use their judgment to convince us to do things. They do not have the power of the purse. They don't get to make laws. They don't have the power of the sword. They don't get to execute laws. They just have the power to convince us to make them or execute them in a certain way. The executive, whether they cooperate or not, and this is why the Solicitor General is such an important position, because it's the conduit between the court and the executive branch. Will they cooperate? Will they execute the ruling? I mean, Eisenhower did not have to nationalize the National Guard to get the students into Little Rock High School. He could have just been disinterested entirely. He decided to defend the status of it wasn't so much he agreed with the position of the court, or he was like, oh my God, the court issued their ruling. He didn't like the fact that Arkansas was thumbing its nose at the federal government. You don't do that to General Eisenhower. So presidents have that. If the court were to rule against Trump somehow when it came to immigration, would he not, quote unquote, obey the rulings? He would be awfully tempted, and given the failure of his first round of impeachment, he would feel to some degree himself bulletproof. Congress can take action that is not cooperative. They can change the law if the court interpret the ruling as this, and the court says, oh my God, we didn't intend that, or we don't like that particular interpretation. They can redo the law. They can change jurisdictions of lower courts other than the original jurisdiction. And this is one of the things they threatened with the Guantanamo Bay. If court, you go too far, we will take your ability to review these decisions entirely away from you. Because the only thing the Constitution guarantees is their original jurisdiction. That's a pretty limited list. Um, they have added justices. There was obviously the big threat in the 1930s to pack the court. They're allowed to do that. For lower courts, they can literally dissolve the court. They can't get rid of the jobs that the justices are holding or the judges are holding. Those judges are still going to be paid, but they're not going to have a court to go to. Um, so they can play with jurisdiction. And of course, they can impeach. And very early on, there was an ardent Federalist who was kind of a jerk, who got impeached mainly because the Republicans didn't like him. There might have been some legal arguments, but it was mostly a political impeachment. And unfortunately for the history of the court, is it failed. Because if it had succeeded, I think many justices would have been impeached and removed because the political branches didn't like them anymore. It was a way to fire them. Fortunately, that case sort of set the standard is you can't just use impeachment of judges as a way to fire them because you don't like them anymore. It would, to some degree, violate the whole notion of giving them lifetime terms to begin with. So those are the structural limitations on the court. The final limitation is us. How much will the American people be willing to go along with the decisions of the Supreme Court, regardless of their support or lack thereof among the political institutions? What about America? I presented on this slide a series of circumstances. You had the Marshall Court, who he was very wise. He picked cases where he could issue a ruling and it was pretty non-controversial. It didn't, even the McCulloch case didn't result in pitchforks and torches being brought to the Supreme Court. You do know from your history class, however, he went perhaps a little bit too far with the ruling in favor of the Cherokees in the Georgia decision, and Jackson issued his famous "Mr. Marshall's made his decision, let him enforce it." So at the end of his term, we're starting to see the ability of no very few people were empathetic to Native American tribes, particularly east of the Mississippi. So the idea that Andrew Jackson was going to face popular blowback for not supporting the Marshall decision was pretty limited. The Dred Scott case, obviously there was an entire half of the country appalled by it. And I think one of the things why it contributes to the Supreme Court is you have, these passions, there wasn't a lot of gray, no pun intended, with the color of the Confederacy. People were either incredibly hurt by the decision or incredibly supportive of the decision. And what cost us a civil war was clearly geographic, above the Mason-Dixon line versus below the Mason-Dixon line, with a little bit of flexibility in the border areas. You then have Brown 2, which said schools must desegregate with all deliberate speed. That speed was incredibly slow. So late in the 1960s, in the Mecklenburg decision, they empowered local federal judges to come in and mandate school attendance zones to force integration, usually by maneuvering people to different schools on buses. It's sometimes referred to as busing. This came up in the Sanders versus Biden contest, and in fact it was Kamala Harris brought it up initially, that Biden, as a young politician in the early 70s in Delaware, was opposed to this, felt it was violating state sovereignty. The protest picture you see at the bottom right is taking place in the city of Boston, and it shows you how passionate people were against this issue of, and Boston, the bastion of liberal America, the California of its day, and yet they had these violent protests against desegregating public schools. The reaction in the upper right corner refers to desegregating. Prince Edward was under court order. Prince Edward County, Virginia was under court order to desegregate. They had black schools, they had white schools. Rather than desegregate and obey the order, they just closed all their public schools. Just closed them and said, "You people, you're on your own. Get your tutors, send them to private school. If we can't conduct our public schooling in a racially segregated fashion, we won't have them at all." Roe versus Wade. Obviously, you've seen the rise of an entire political Christian conservative movement that, contributed to the rise of Reagan in 1980, and the Falwells, the Robertsons of the world. Um, they rule the other way. They leave it to a patchwork of state decisions. In all likelihood, as we modernized and the 20th century moved on, a majority of states would have expanded abortion access. Some states would not have, but there would not have been that political national impetus for the Christian right movement, the neocons of the social conservatives. Bush versus Gore. There were protests about this decision. It all sort of came down to Al Gore deciding to accept the result and not pursue the legal options that he had under the various electoral college laws that existed. He decided to accept their decision, and his doing so probably tampened down opposition. And then, of course, after 9/11, it was sort of, not something he necessarily brought up. Obergefell versus Hodges is the case in which Kennedy decides, I'm not waiting any longer for the states to accept same-sex marriage. I am just going to now flip my vote, so it's 5-4, saying the 14th Amendment tells the states, if you issue licenses to heterosexual couples, you have to issue licenses to homosexual couples. Now, like schooling, you don't have to issue licenses at all. If you want to turn marriage over to private contractual arrangements that you arrange through a lawyer and ceremonies that are handled by various churches in the states and not licensed marriages at all, you're free to do that. But if you start licensing, you cannot use sexual preference, gender preference, as a means to sort out who gets a license and who doesn't. There was concern that the country was not going to be, and there are certainly probably parts of the country not crazy about that now. But the degree of protest, the heat of the protest after the decision, I think sort of disappointed some who thought there might be more, and I think we've come to accept it, and that maybe Justice Kennedy hit it at exactly the right time to make this ruling. Yes, he could have said, I'll wait, and gradually there will be a wave as states, one state after another, have to recognize this. But we didn't get the response. So you see very, geographic differences, reactions of the public being largely indifferent to most of what the martial court's doing, to being aggressively hostile in certain areas, to being not hostile at all. So there's a mixed bag, and there is no doubt. And any Supreme Court justice who tells you the reaction of the public doesn't play a role at all in their decision are full of crap. It's got to be in the back of their mind, because they, going back to the previous slide, recognize their position, even come the 21st century, is tenuous at best in our system. Thank you, James Madison. Thank you, Alexander Hamilton. And thank you.